provisions. Let me take a break here and ask so far if there are questions. Am I going too fast? Is this fine? Any feedback?
Yeah, Sachin, to start with, yes, there are a few questions, and I think, no, you're going good. I think you're reasonably paced. So I think few questions I'll pose to you, Sachin, and you could answer that. So first one was from Ashish. What action was taken on the government officials? So since in the case study you said, some government, there were bribery, etc., Mondelez and stuff. So was there any action taken against the government officials in your knowledge?
I think I saw some references in one of the news item about potentially some action under Indian law, but I will have to go back and search. I do not have the details. The reason being, I will show this point at the end of the presentation that there is a gap in the way FCPA is designed versus how the Indian law is designed. Indian law prohibits both the giver and receiver of the bribe, and makes it an offense, and there is a punishment provided for both. US FCPA focuses on the giver of the bribe, but recently government actually enacted in the US in December 2023 a law called FEPA, Foreign Extortion Prohibition Act. I have a slide at the end of it, and that law is designed to prosecute the seeker or the receiver of the bribe. But under FCPA, there is no action. In the specific example, whether there was an action under Indian law, I will have to go back and search. I'm sorry, I don't have answer at my fingertips.
Sure. Okay. That just out of curiosity, that leads me to one question, Sachin. That if a US subsidiary in India is covered under FCPA and some bribery action happens in India, will POCA also apply in India to that extent?
POCA may apply if the enforcement is instituted. If someone makes a complaint, police receives an FIR or a complaint, and then investigation machinery is set into action, then it will apply.
POCA may also.
Typically, the reason why US Department of Justice or Securities and Exchange Commission make it public the information about the instances of penalties, etc., despite that these penalties are paid without admitting or denying the liabilities, so that if the action has happened in a particular country, then the local enforcement authorities can then take note of it and decide if there is a scope to take a suo motu cognizance and initiate. So depending on how big is the action, whether it is known to the regulators in India, depending on all those factors. In some examples, cases have happened. In some examples, cases have not happened in India.
Right. And okay, next question is, are joint venture companies covered? A couple of people have asked that. Joint venture companies, so since you said subsidiaries, so if it's a 50-50 joint venture or in any other proportion for that matter, suppose there's only 20% shareholding by the US company of an Indian company, will those kind of companies be covered?
I think so, because ultimately, to the extent of those shares, the legal entity represents the US business, right? And normally, US company and Indian company will collaborate through a joint venture or other arrangement, because they want to use the US products or technologies to be utilized for business in India in whatever form, right? So ultimately, fully or partially, the US products, US brand or US technology is being sold to the customers in India. And in the course of those transactions, if improper payments happen, then that's what US government wants to prevent.
So it is not just subsidiaries, but even joint venture companies and associate companies also will be.
Yeah, I mean, if you just take the analogy that even a distributor who may not necessarily be a shareholder in the US company, it is an independent principal to principal relationship. If a distributor, consultant, contractor, or service provider is brought under the purview of this law, then why not a joint shareholder?
Right. Now, on the facilitation payments, there are many questions on facilitation payments. I'll try to club some of the themes and ask you questions, Sachin, that in India, especially in the Indian context, with, of course, no offense to India, we're all Indians, the speed money, those kind of minor facilitation payments have been very, very prevalent from times immemorial. And things like import of goods, things like some licenses, registrations, approvals, etc., from several government departments do involve certain times facilitation payments. Otherwise, either those things do not happen or they take a lot of time, which can lead to a lot of financial implications or other business implications.
Right.
Now, if it's a very, very important critical, say a registration or a license, say, or a clearance of a shipment, and where the payment could have been 5,000, 10,000, or or of the likes, but the amount involved would be few crores. So, so is there any criteria? I saw, this is a learning for me, that facilitation payments are allowed, or but with no threshold. So, are there any threshold for facilitation payments? Isn't it a loophole? If there are no thresholds defined, then is 10,000 appropriate, 1 lakh appropriate, 10 lakhs appropriate? How will materiality be decided? And is this practical? Means without the facilitation payments, can you really do business in India? These are some of the 2-3 themes I just combined.
Well, not surprised with this question. I would like to say, if you historically look at a lot of government processes, all of us will appreciate that since last 10 to 15, 20 years, there has been so much of improvement in so many government processes to eliminate the bribery. So if you look at customs, right? So when I'm importing a product, I'm supposed to get my valuation done from special valuation board, and I'm supposed to self-declare the value of my goods and pay the customs duty, right? And get it cleared, right? If it gets stuck, then I get an official communication. And if when the customs officer know that this company is bringing all the right information, they will resolve that issue. If I take registration of products with various regulatory authorities, for example, medical devices or pharma drugs, there is a Sugam portal which government has created, where the registration for import and sell of the products in India earlier was on a paper basis, where a drug inspector would review my profile, my dossier. Now it is all done automatically. There is a turnaround time in a lot of various the different authorities. There is a deadline put on the regulator by government by saying that within X number of days, if a license is not issued but application is submitted, then it is deemed to have been issued. So there is so much of technological element that is coming in to reduce the human interface, to significantly reduce the risks of corruption. That's number one factor. Secondly, facilitation payment may be acceptable under US FCPA, but we are all working in India, and there is no such element in under Prevention of Corruption Act. So even 10 rupee of a facilitation payment that may be acceptable under FCPA, it might still qualify as a bribe under Prevention of Corruption Act in India, because again, there is no concept of facilitation payment under Indian law. So strictly speaking, going by the rule of the law, it is not acceptable in India. Secondly, a lot of US companies, I've worked with 2 or 3 different US companies, and we have gone ahead, in several instances, right from getting a Shop and Establishment Act, inspector visiting my warehouse or my distributor's warehouse and saying, hey, I found some issue in your label, and if you pay so much of amount, and we have said, sir, please go ahead and issue show cause notice. According to me, my label is clear, but if there is an issue, I will review it, and then I will follow the provisions. And sometimes they threatened us to seal our warehouse, and we have gone to High Court and said we have made necessary representations, grant us protection. So if companies take a hard stand that I will do business only in the right way, nowadays it is very difficult. It is very difficult from both the sides. It is very difficult for government officers who are now very clear about their own reputations, and so much of tightening of the system. It is very difficult for government officials. There are so many good government officials. At the same time, not just US companies, but Indian companies have global presence. They are collaborating in several countries, doing international businesses. A lot of people care for their reputation. So it is a push and pull from both the sides. On one hand, technology is making it easy for things to move faster, and the instances of giving improper payment are significantly reducing. On the other hand, it is not acceptable under Indian law. So my advice, straight advice, is just avoid it. Go ahead by the rule book of the law. If things get stuck, make a representation to the regulator, pursue, provide them whatever information they need, and then once they understand that you are a right intended company, then they will go ahead and clear whatever is stuck.
Understand. All right, that's good information. Just on a lighter note, as you mentioned shop and establishment, you also mentioned technological advancements. Everything is coming online. Things are more transparent. just want to share 10 seconds on a personal experience. Personal means, of course, professional experience, handled personally. We applied for a shop and establishment license for one of our clients, and we, of course, the mandate was that it has to be completely above board. No facilitation payments or speed money is required, and it was an online application filed in the relevant state. And can you believe that the application, which was supposed to be approved within 3 days, 5 days, 10 days, was not approved for 2 months, 3 months altogether, because there was no visit made to the department, no sort of liaison done with the department. And it was so surprising that even in the online mode in certain departments, nothing happened. And then when the client lost patience and he said, I'm not getting it. So we said, yeah, this is how you advised us, and this is what we've been doing. The day the liaison was made, we got the shop and establishment the next day. So, this is sometimes the sad state of affairs, even in online, where unfortunately there is no monitoring that when the officer is supposed to approve the application, that approval discretion, if nobody is monitoring it, even the online doesn't help, without the offline liaison. So, that's a sad state sometimes.
No, I don't want to completely disassociate myself and sitting in an ivory tower and make a statement. This is not possible. But if I was there, I would have sent an official representation and reminder. And if I was the legal counsel of that company, I would have asked the management to hold on for a few more days and write an official route. So it really boils down to the patience level and ethical decision making of the company and the management to say, okay, am I willing to wait for a few more days and do the right thing? If they decide to do that, it normally doesn't take that much time as we used to see in the past.
On the other hand, there have also been great examples, as you're rightly saying, US MNCs, stamp duty adjudication, these are common matters held because of lack of supervision of the revenue department, applications lying pending for months and years altogether, not just months, years and years, and they're just not getting adjudicated. And there's enough and more patience and tolerance in the company saying, let us, we have filed, we have done our job. If they are not adjudicating, that's their problem. If he receives anything in writing, we will go ahead with it, and that's about it. That was a stand, and then of course then they received the adjudication orders despite after several years. So these are also some stands taken by companies. Yeah. All right. So Sachin, in the interest of time, please go ahead. You can finish your presentation. There are more questions as well. Many more are trickling in, but we have to finish it as well. So you finish your part, and then we'll do a rapid fire of the questions towards the end of the session.
Sure.
Welcome. Yes. So here you go. Sachin, so whether any payments are made under duress is also an exception under FCPA?
Yes, if it is made with corrupt intent, yes.
Right. Okay. How to decide reasonable amount for Diwali gifts? Internal policy means what is the threshold, or should be the threshold?
There is no limit provided by law, but I would ask people to use what is called as Times of India test. Imagine the information about your gift is coming on the first page of Times of India. Will it make you uncomfortable?
Wow. Yeah, I've spent 5 years with G Capital, and this is exactly what they used to say. The newspaper test. Whatever you're doing, if that's is in the headlines of the next day newspaper, will you be in a good light or bad light? So that's the deciding criteria. All right. Any examples of POCA? Any cases that you would have come across under POCA other than the FCPA?
We have come across cases with POCA and other regulatory authorities where even the involvement of companies and channel partners during tenders, and we have seen regulators taking strong action against the Indian officials also, not just against the givers of the bribe. So now the whole environment is quite dynamic in that regards. No one wants to take risks with their reputations, neither government officers nor companies.
Understand. And do directors or officers or are they personally liable under FCPA?
They are. I gave you examples that in the Cognizant example, it is public domain that the global CEO and global GC, global general counsel, had to resign. I don't want to make a statement why they resigned, but it is in that news item, it is publicly displayed that they were resigned. There are other examples where senior executives were resigned, and I was told that there are examples where people have been prosecuted. Now, the Rajat Gupta case, who is the CEO of Goldman Sachs, is not a FCPA case. It's another type of case, but it's a celebrated Indian American leader who who violated the laws and had to go in jail for 2 years.
Yeah. Sheetal asks, if this facilitation payments, why it is there in the Act? Means it's quite strange. Of course, we can't fathom it in the Indian law, but when there are thresholds not defined, so why should facilitation payments be allowed in the laws for any official to do his official duty?
If you look at it purely from an Indian context, it doesn't make sense. But you have to imagine that this law was enacted in 1977 in the US, and in their cultural context, they thought it might make sense.
I understand. And Swati says, what are the consequences faced by the third party who is involved in giving the bribe to the giver?
Sorry, say that again.
So the consequences for the bribe giver.
So again, under FCPA, the bribe giver is directly liable, right? So
Sorry. I'll reframe the question. What are the consequences faced by the third party, maybe an intermediary, consultant, or a distributor who is involved in giving the bribe?
If third party is involved, then third party will be prosecuted. We'll have to go through the whole process. I don't exactly remember the example of third party being directly prosecuted, but I showed you the example. Again, I would like to make it clear, there is no conclusion about liability of L&T, but the chairperson of L&T is being summoned in the US. That itself is a pain for such a senior executive of a reputed company who's supposed to look at the customers and grow the business rather than go and depose in the witness box.
Understand. Vijay says, does POCA cover private companies as well?
Yes.
Okay.
It covers private companies on both the sides, givers and takers.
Understand. Kosa Raju says, in these cases of Mondelez, etc., while the foreign company was proceeded against in that country due to non-sharing of information and investigation reports, no action has been taken on the actual recipients of the amount of bribe in India. So it's more like a comment. You have anything to say on that?
No, I have not gone into the details of the recipient side.
Understand. Pawan says, up to what amount the government officials are allowed to accept gifts of hospitality?
So typically government officials have their own internal protocol, whether they are allowed or not. Companies should have their own protocol. As I said, it should meet the test of reasonableness. It should not be so high that the government official should feel obliged, right? If it is reasonable, if it is low value, if it is done across the board, if it is properly recorded and it doesn't cause you embarrassment if it comes on the first page of Times of India. These are some of the criteria you should consider.
Understand. Anurag asks, does the company need to have an in-house facility for hotline, or can it be outsourced?
There are most of the US companies go to a company called Navex Global. Navex Global is responsible for managing hotline of most of the Fortune 500 companies, and that they have their own reputation. If you ask me, I would always recommend to go with a third party, because then there cannot be an allegation that there was a complaint against the CEO or CFO and the company itself put it under the carpet. If it goes to a third party, then third party under no obligation to hide it. They will directly disseminate information. And in case inquired, then one can. So it creates a credibility if you give it to a reputed third party.
Understand. And also, just to mention, since this question has been asked, our sister law firm called eMinds Legal, which is a corporate law firm in India with around 60 people, we are also managing a couple of hotlines for some MNC clients, where people can email in a email box, or there are some hotline, there are numbers created, virtual numbers, which can transport to a particular official. A lawyer will attend that and transport it back to the company, etc. So if you are interested, you can reach out to the Complinity team and they'll connect you to eMinds Legal. All right. Subhadeep says, can we get the PPT? Subhadeep, you follow all our channels, you will get PPT in different forms, in terms of podcasts on Spotify, or videos on YouTube, or some blogs on LinkedIn, and many more resources you will get. Please subscribe to all the channels. My team can again put it in the chat box for easy reference. Okay. Subhadeep again says, does attorney-client privilege work for in-house counsels in India? That's not an FCPA question, but still.
It is generally it is a debatable question. Some lawyers in India believe that it applies in India. Some lawyers believe it doesn't apply. But in the context of FCPA investigations, most of the US companies prefer to engage a US law firm and bring a US qualified lawyer who is member of one of the US state bars, so that then they can certainly administer attorney-client privilege. In India, there are arguments on both sides.
Done. Mangesh Karande, if the vendor pays a bribe to government official for their client work and client is unknown to this bribe paid, is the client in problem under these acts? Means he's
Yes,
saying
yes.
the intermediary is paying, but client either is not aware, or maybe he says that he's not aware, is still the principal still liable?
See, the underlying principle is the principal company is responsible for the acts of their distributors, third parties, or intermediaries. Doesn't matter they know or they should have known, right? So the duty is cast on them to make sure that they know. So ignorance is not an excuse, unless they are able to really produce significant, evidence that I have a program, I have helped this, vendor with a tool, etc. So there are a lot of ifs and buts, but the bottom line is the prevention is an expectation.
Right. Shanu says, while accepting a contract or declaration of FCPA, how much level of negotiation is acceptable? Being a third party, in some cases, one cannot have full access to internal accounts to their clients.
Yeah. So see, we have come across this situation when we were doing distributors of audit of distributors, and distributors would typically say that my purchase register and my sell register combines products of 3 or 4 different companies. So so typically US companies would insist that anti-bribery policy is not negotiable because it's a global policy. You can seek guidance in terms of how to maintain accounts in such a way that I'm able to give access to your company accounts by protecting confidentiality of other company accounts. And there are ways to do that in SAP and other systems.
Right. And the question, I think that's already been answered, applicability of to the Indian law, so to the Indian company. So if I'll only sort of go ahead, I'm educated good enough for the last 90 minutes now, that yes, if the subsidiary or any associate company in India, which is a subsidiary or associate of a US company, or even if you're an intermediary or a consultant and acting on behalf of a US company in India, then FCPA very much applies to you. And as Sachin said, not just FCPA, Prevention of Corruption Act, which is the Indian counterpart of FCPA, which is also equally or more strict because it covers both the bribe receiver and the bribe giver. That will also apply. So you may be charged under 2 laws: FCPA by the DOJ, Department of Justice in the US, or SEC, and COCA by the Indian authorities as well. So that's one. And a couple of examples or stories, 1 or 2 stories I would love to share with you very quickly before we wrap up the webinar today. One is when I was general counsel in my last job 10-12 years back in a UK MNC. There was a sweet box gifted to me along with this. Also, it was also gifted to the CEO and the COO by the landlord. We were a tenant in a large commercial complex, and a sweet box came just as a goodwill gesture on Diwali. Maybe the value would have been 500-700 rupees only. And there were questions on whether we can accept it, whether we cannot accept it. There were mails written to the compliance lead in the UK that this is, explaining them that, okay, Diwali is a festival of lights in India. It's customary for people to give sweet boxes. If we deny it, it will tantamount to rudeness. Can we accept it? And then the CEO, by the way, of course, we got the approval. But the CEO said that, okay, accept it on my behalf, but distribute it in my team. So he was saying, okay, you can take it, but I don't want to touch it. Just distribute it in my team.
Don't take it to your home.
Yeah. So and also I've seen some of the clients where we ourselves have offered diaries, as you also took a diary example, diaries or pens, the value of which could not be more than 100-200 rupees probably. They very clearly said, no, not even diaries. We'll err on the side of caution. It's completely not allowed as per company policies. And I was wondering, not even a 500 rupees threshold, because for these things. But some companies take it to the T. They take it in letter and in spirit, saying this is just not allowed in our policies, and we will really comply with it in letter and spirit. And one more, example. It's interesting for me to share. When we onboarded a US client, you will not believe they took our banking details from us, and it was incidentally Axis Bank in Gurgaon. They took the relationship manager details also, and our relationship manager got a call straight from the US, where the client was asking that whether do you see any suspicious activities in the bank accounts of us, like as a service provider. Imagine that's the first time I heard, my RM calling me saying some US client of yours is calling me asking that whether can he see some suspicious transactions in bank accounts. So he was confused, how to respond, what to say. Of course, everything was clean, but these kind of onboarding due diligence, you may call it, where it's not just documentation submitted by the service provider to the client, but clients calling the bank directly. I don't know how much banks are authorized to share this on calls or emails. That's another question. But those are some of the examples, Sachin. I also wanted to share with you my interface with some of these things. Yeah.
I was also a couple of times bombarded with chocolates, and once it came as an artifact, and it was very difficult to courier back the artifact. So we found a creative way to handle it. We said we are going to put it on auction. Whichever employee wants to buy it, the proceeds will go to charity.
Wow.
We did that.
That's a wonderful thing. So, accept bribe, even if you accept, not bribe, but even if you accept some gifts, don't take it home, auction it out.
Never.
So, yeah.
Never.
All right. No, and another, on a lighter note, Sachin, for example, if you receive a gift and you cannot take it home, you can of course courier it back to me, and because I didn't receive it from the ultimate giver, and you can gift it to me. I don't mind taking it, right? But of course, it has to be within the thresholds. You don't bribe me at all.
Welcome to Complinity Technologies. Complinity is India's leading governance, risk and compliance software helping companies to manage their compliance, contracts, litigation, legal updates, inter-financial controls and more. Complinity is a one-stop shop for all GRC needs. With our proprietary 12 GRC modules and real-time legal updates on 2,000+ laws and 24,000+ compliances, all in an integrated platform that is easy to use with automated alerts and risk management capabilities, is why compliance managers, general counsels and chief financial officers choose Complinity every time. Join the most innovative and prestigious brands that use Complinity. Automating your compliance management. Request a demo at complinity.com.